Okay, so I think we can get started now. Hello and welcome to tonight's #While Our Virtual event on COVID-19 6 months on. My name's Kira Bartlam. I am a While Our committee member and I am joined tonight by 4 fabulous activist lawyers. We've got Rose Arnall from Shelter.
Hello.
We've got Ros Comyn from Liberty.
Hi.
We've got Alice Irving from Doughty Street Chambers.
Hello.
And we've got Lady-Gené Waszkewitz from 25 Bedford Row.
Hi.
So thank you all for joining us. We're delighted to have you here. I just want to give a big shout out to One Pump Court for hosting us tonight. We are incredibly grateful. They've been hosting us throughout the summer and it's been a real help. So tonight, COVID-19 6 months on. I don't know what your 6 months has been like, but mine has been like a bit of a roller coaster. My mental health is battered. I am shattered. We've had some highs, we've had some lows, we've had some real fights. Obviously, it marks 6 months since the start of lockdown, but also the start of the Coronavirus Act, which brings us here tonight. We're going to be hearing about Liberty's campaign to scrap it. We're going to be hearing about landmark victories that have been going on throughout the pandemic, pardon me. And we're also going to be hearing about the experience of lawyers and their clients on the ground, and particularly as we ease out of lockdown. So all really hot topics. I wanted at the beginning just to give a shout out to our While Our committee member, Emma Trevitt. She, as you may know, suffered a stroke 10 days ago. And so we just wanted to wish her well. She's making a steady recovery from what I hear, and we're really glad to hear it. But Emma, we're thinking of you, and yeah, wish you all the best. In terms of how it's going to work tonight, you'll have all been to way more Zoom meetings than I have, so you'll know it well. There is a Q&A button at the bottom of your screens. The chat for tonight is disabled, so you won't be able to use that, but please put all of your questions in the Q&A and our speakers will answer them at the end. We're going to give each speaker about 10 to 15 minutes to speak, but don't feel that you need to leave your questions to the end. You can put them in at any time. So I think that's probably it from me, apart from to say, I'm just checking my notes, that we do have a privacy policy. It is available on our website. Do check it out if you want to. So with that, I'm going to kick off with Rose Arnall, who is a solicitor at Shelter, and she's going to be talking to us about her most recent victory in the No DSS campaign. I won't go into detail of it, I'll leave that to Rose, but it's safe to say that this is a huge effort by her and the rest of Shelter. It's been a 2-year campaign, so really tremendous work. And over to you, Rose, to tell us a little bit more about it.
Thank you, and hello everyone. So I'm going to try and get through this as quickly as possible, but shout if I'm speaking too fast. So I work for Shelter, which is the housing and homelessness charity, and as Cara said, 2 years ago we started our campaign to end DSS discrimination. DSS stands for the Department of Social Security, which has long since been abolished, but it's used as shorthand, or has been used as shorthand in adverts by private landlords to represent housing benefit, or the housing element of universal credit. And it basically means that they will not consider applicants for a tenancy of a property, even if it's suitable and affordable for that person, just because they're in receipt of state benefit. So obviously these practices limit the choice and opportunities for renters who are in receipt of benefits, and it makes it a lot harder for them to access a suitable home, which contributes to keeping them in poor housing or facing homelessness, but also adds increasing pressure onto social housing, which is obviously dwindling to non-existent. The problem is widespread and it's increasing. So we've carried out research on this since 2015, when 42% of landlords operated an outright bar. In 2016, it was 55%. In 2017, it was 80% of private landlords said they were unwilling to let to tenants in receipt of housing benefit. in 2018, 1 in 3 renters who were in receipt of housing benefit have not been able to rent a home due to a no DSS policy in the last 5 years. So because there are about 4.5 million households in the private rented sector, of at least 1 million of those claim housing benefit, our calculations were that it's the equivalent of hundreds of thousands of people being exposed to this kind of prejudice in recent years. So although being in receipt of benefit is not a protected characteristic for the purposes of the Equality Act, and so a ban on renting to people in receipt of benefit is not directly discriminatory, because people who are women or who have disabilities are more likely than men or those who are not disabled to be in receipt of housing benefit, they're more likely to put at a particular disadvantage by such policies. So our view was that it was potentially indirectly discriminatory if it couldn't be justified for a legitimate aim. So we started our campaign in 2018. We really did our homework, because there were lots of excuses being bandied about by landlords and letting agents as to why they carried out this type of discrimination. And we wanted to make sure that, see if any of those were legitimate. The aim of the campaign is to completely stamp out the discrimination so that every tenant is treated fairly on a case-by-case basis and judged not on the source of their income, but on relevant factors like, can they afford the rent? Have they got a good rental track history? Is the property suitable for them? And we are an interdisciplinary team at Shelter that meet every week. So we cover research, campaigns, media, legal, and local grassroots groups and individual landlords. So the campaigning side of it had a number of successes in the early year. Mortgage lenders changed their policies because they had some restrictions in buy-to-let mortgages. The Competitions and Markets Authority, who I'd never heard of before, had provided supportive guidance, which was then adopted by organisations such as the Guild of Letting and Management. The Property Ombudsman issued a reminder to all agents of their obligations not to discriminate. The Department of Housing, Communities and Local Government called for an end to DSS discrimination, and the Residential Landlords Association agreed that, as a matter of routine, landlords and agents should not preclude benefit claimants from being able to rent a property, and that they should each be assessed on a case-by-case basis. However, we continue to see it on the ground, and some major and important actors expressed doubt and confusion over the legality of it. Rightmove, for example, one of the biggest property portals, said the government's own advice is not definitive on whether or not it's unlawfully discriminatory. There was no reliable, still is, no reliable indication of what plans, if any, the government had in relation to legislating directly against DSS discrimination. And there's nothing at present other than the Equality Act to try and bring a claim. So we had 6 settled cases pre-litigation, 3 at early stages where the opponents agreed to apologise and change their practices and pay our legal costs. But very much the view of the private sector was, unless or until it's tested in court, the issue will remain unclear. They just didn't want it to, they weren't willing to see an end to it unless we got it all the way to trial. So in July, I had my first ever virtual hearing, which was interesting and nerve-wracking, and you're just praying that like the cat won't jump on the laptop right in the middle of it. So that was for our client Jane, who is a single mum from York, who was also disabled as well as being a woman, and she'd rented for 10 years, could afford her rent, had 6 months rent in advance, home-owning guarantor, work part-time, and applied to rent a property and received an email from the agency saying, we've had a policy for a number of years of not accepting housing benefit tenants. She and her daughter were left homeless as a result in a homeless hostel, and although she wasn't eligible for legal aid funding, the Equality and Human Rights Commission agreed to provide some funding. So that was really, really great and helpful. Right up before the trial was due to take place, the opponents made an offer to settle of $3,000 worth of damages and a confidential, non-disclosable acknowledgement that our client had been treated less favourably on this occasion due to her sex or disability. we weren't happy with the terms of that settlement. The Equality and Human Rights Commission were nervous about the cost risks. Obviously, they were the ones with their neck on the line, and they asked us to try to settle. We counter-offered to the opponents. We said, look, we'll keep your name confidential, because for us it doesn't matter. We know it's happening across the country, and it wasn't them in particular. We said, look, we'll keep your name confidential if you'll agree not to oppose our application for declaratory relief to the court. They agreed to that, so we made the application, had the hearing online, and on the 1st of July, the court issued a declaration that the defendant's former policy of rejecting tenancy applications was unlawfully, indirectly discriminatory on the grounds of sex and disability. But I mean, it was great. We got a lot of media, and there was some great reactions, but we hadn't had a fully contested trial, and so there were still people saying, well, you haven't really tested it, you know, they agreed in the end. So we carried on. Luckily, we had a trial scheduled yesterday in Birmingham County Court that was fully defended. So I spent, if I'm jumbling my words, it's because I was all day in court yesterday with a client of mine who we've worked with. He's been with us right from the beginning of the campaign 2 years ago. He's done media work for us. He's so committed to the campaign. He's just completely a part of it. So he is a disabled dad from Birmingham, and he's got 4 children with his wife. They had also privately rented successfully for 10 years, always paid their rent on time, had a deposit, rent in advance, guarantors, 4 different people willing to be guarantors for them. Inquired about suitable properties that were near to the kids' schools, his GP, and their family support network, which was really important for them. And were told by the biggest letting agent in Birmingham that they had a company policy of not accepting housing benefits. We managed to get legal aid for that one. He wasn't financially out of scope. And as I said, it was fully defended. I don't know why this one got all the way to trial, because I don't think it was, you know, it wasn't weak on our side. But anyway, there we go. You never know which one's going to be the one, do you? So we're still awaiting a copy of the court order, because it all just happened yesterday, and we have ordered a transcript, which we're going to share as soon as we can. But I'll just give you a couple of highlights of the court's judgment. It was a real roller coaster of emotions on the day, as they often are, when you're seeing your client who has done so much for us, for our campaigning point of view, being cross-examined the way that he was. It really was very hard cross-examination. It's difficult to see your client going through that. They made all of his family members to come to court as to give their evidence physically in person. We were yesterday, so and then they ended up just asking each witness just a couple of questions. It was a difficult day, but by the end, the judge said the legal issues really crumbled to dust during the course of the hearing. Love that one. There was no doubt that there was a blanket policy that no one in receipt of housing benefit would be considered for the 3 properties, and that this was a PCP as defined by the Equality Act that applied to all people, but particularly disadvantaged people who are disabled. This was demonstrated clearly by the evidence from Liam Reynolds, who is our senior research officer at Shelter, who was able to prove that people who are disabled are at a greater disadvantage. The defendant accepted that they could not show that there was any justification. It was not a proportionate means to achieve a legitimate aim. And the court duly made a declaration that the defendant unlawfully, indirectly discriminated on the grounds of disability, obviously not sex in this case. And her view was that it was a serious matter, that the claimant's feelings had been damaged considerably at a time when he and his wife were desperate. At the time, his wife was 6 months pregnant, and to be told simply because of his benefit status that he could not apply for any one of the 3 properties that were perfectly located for their family needs that he could afford would be distressing. That injury to feeling had been aggravated by the manner in which the proceedings had been conducted, with the defendant seeking to assert that he had made it up, that he was lying, that because of his mental health issues, his memory was not reliable. I mean, this is what was going on in the cross-exam. It was horrid. But the judge recognised that and said the nature of the cross-examination added further injury to feelings, and so bearing all of that in mind, gave us the maximum amount which we'd claimed, £6,000 plus interest, and gave us costs on an indemnity basis, which she said she rarely does. And finally, when speaking to the defendant's barrister, I'm trying not to look too smug, the judge said, "It was just a hopeless case and you made all those witnesses come. Poor Mrs. Wimlett, who was our client's mother-in-law, in her wheelchair. You couldn't possibly have succeeded, could you?" So, I mean, we're thrilled, smiles all around. The client was very happy. So I realise I'm running over my time, but just to say, in terms of the future, we do have some other cases ongoing. Let's see if they settle now that this hopefully gets a bit of publicity, and I really look forward to sharing the actual order and the judgment with everyone as soon as we can. All right, I'll end there.
Thank you so much. And we really look forward to reading it. I mean, you should be smug. That's an incredible victory. And what a judgment as well. Absolutely fantastic work. True social welfare lawyer, like activist lawyer at that. So thank you for sharing it. So next we're going over to Ros Comyn, who is a policy and campaigns officer at Liberty. And you have been phenomenally busy, I think, well, as everybody has, but particularly over the last 6 months. And have, I think, done quite a lot. I Googled you earlier and I found out that you've given evidence to the Home Affairs Committee. You've been running a series of campaigns, like really, really on it. And I hope that you're going to talk to us about your latest campaign, which is to scrap the Coronavirus Act. Is that right?
Yes, I will. Thank you so much, Kira. And thank you so much for inviting me. And it's so amazing to follow you, Rose, and follow that story and like a hopeful win in a time like this. It's fantastic to hear. So massive congratulations. So yes, my name is Roz. I work on the policy team at Liberty. So I am actually not an activist lawyer, though I am a friend to activist lawyers. But I work primarily on policing and on counter-terror. But we've been very busy, as you say, Kira, through this pandemic, working on the kind of fallout of the government's response to coronavirus. And I'm going to speak a bit today on about our campaign to repeal the Coronavirus Act, which cuts across, as a piece of legislation, it cuts across many strands of our work at Liberty, and reaches into so many different areas of our lives. So I'll speak a bit about the Act itself and its impacts, and what our campaign looks like and what next steps are on the campaign, and how you can support if you'd like to support the campaign. So in terms of the Act itself, as many of you may know, in March of this year, the government and Parliament, when faced with the significant risk to life that the pandemic posed, they nodded through, without any vote, some of the greatest restrictions on civil liberties in at least a generation, and that took the form of the Coronavirus Act. And the Act was scrutinised and passed in a single day, with barely any amendments and without what's known as a sunset clause, or at least without a firm sunset clause, so that we'd see when those powers could expire, so they wouldn't be on the statute books indefinitely. And in terms of the substance of the Act, it's huge. It's a colossal piece of legislation, and it contains a host of really coercive powers. So powers to close borders, cancel elections, powers to ban gatherings with no exceptions for exercising rights like your right to protest or to strike or demonstrate your opposition to state practices. It confers really significant powers on the police and on immigration officials to detain people that they determine are potentially infectious for testing. And potentially infectious is defined so broadly so as to basically it can capture kind of any part of the population at any given moment. And the powers also allow public health officials to demand that people provide biological samples or other kind of personal data relating to their health or their personal relationships or travel history, or face a fine or prosecution. And it also empowers public health officials to require people to essentially isolate, to remain indefinitely in a particular place without any upper time limit. And so that's the kind of a kind of whistle-stop tour of some of the really coercive powers in the Act. But it also the Act kind of failed in its, there's like gaps in the Act. It basically didn't really kind of acknowledge the differentiated impacts of the pandemic, and also left people even more exposed to infringements of their human rights and civil liberties by stripping away particular safeguards that people would have had in ordinary times. So in particular, the Act makes provision for changes to the Mental Health Act by rescinding a number of important safeguards for people who are experiencing mental health problems, and other provisions, which Alice might speak about a bit later, allow local authorities to apply what's been termed easements. So essentially weaken protections that people have under the Care Act at a time when people, you know, in need of care might have lessened kind of networks of informal social support because it's restricted by way of social distancing or other government regulations. So that's the Coronavirus Act. And at the same time, rather than introducing a statutory basis for a lockdown in the Act, the government chose to introduce lockdown by way of a series of statutory instruments implemented under the Public Health Act 1984. And those regulations have kind of been made with really ever decreasing justification under emergency procedures, which basically allows the government to delay any parliamentary debate. So there doesn't need to be any prior parliamentary debate on any measures they implement, and debate can happen several weeks, if not months, after the laws have actually come into force. And then in terms of the impacts and kind of how we've seen these powers being used, the first point to note is that lockdown, as I mentioned, or a legal basis for lockdown has been implemented on the Public Health Act. Powers under Schedule 21, those powers to detain potentially infectious people, have never lawfully been used. The powers to kind of reduce safeguards around mental health haven't been triggered in England. And while 8 councils have used those evening powers, those notifications have all been withdrawn. So I think that's an important contextual point to think about whether these kind of really extraordinary powers are actually necessary. The second point is that, I mean, this is just a really obvious point, but these are really eye-watering powers. They represent a really extraordinary expansion of state power over all of us. Obviously at an extraordinary time, but that risks normalizing the concentration of power in the hands of the executive and in the police, and setting a precedent for extraordinary restrictions of the general population in response to kind of any future situation that could be construed as a crisis. The third point in terms of looking at the impacts of these powers is that it's clear that a combination of sweeping powers drafted in haste and discrepancies in public communication, where the government have kind of repeatedly conflated law and guidance and kind of been making inconsistent statements, has not only eroded the rule of law, but also been a recipe for arbitrary use. So there's been very well publicized instances of police overreach when they're purportedly using powers conferred by the secondary legislation made under the Public Health Act, but also Schedule 21, which are the powers to detain potentially infectious people. There were quite serious concerns about the ways in which those powers were being used, and that prompted the CPS to review all charges under Schedule 21, and that review concluded that every single charge had been unlawful. So that Schedule 21 has never been lawfully used, or has never been lawfully charged. The third point I make is that there's a really rich body of evidence that trust is a very precious commodity during a public health crisis. And in all the kind of public health literature and research, one of the key points is that we should be persuading people and facilitating compliance by way of clear messaging rather than kind of coercion and control. These powers really do the opposite. So I think there's a really concerning risk, or there's a big concern about how these powers impact public health more broadly. And that's obviously, again, not evenly felt across the population. So the threat of criminalisation for non-compliance might have the perverse effect of deterring people from accessing services. And that's particularly concerning where, for example, measures aren't in place to facilitate compliance, such as ensuring that people can meet housing and food costs while they're self-isolating, or that people are reassured that it's safe to share data with state agencies without fear that it will be shared with the Home Office for immigration enforcement purposes. So that's the kind of public health concern. A fourth point in terms of the impact is that at Liberty we've collected a lot of evidence that there's been racially uneven enforcement of these powers. So a really high profile and concerning case was the first person to be wrongly convicted under Schedule 21 was Lady-Gené, a Black woman, and a subsequent investigation by our new investigative unit, Liberty Investigates, and The Guardian revealed that under the lockdown regulations, people of colour were 54% more likely to be subject to a fine than white people, which is incredibly stark, but also not that surprising, because these powers weren't conferred in a vacuum. You know, these patterns of enforcement mirror existing patterns of enforcement in police powers, and communities that are already over-policed have borne the brunt of them, and it's really revealed communities squeezed between the government's response to this pandemic and the pandemic itself and all the costs that that carries. How am I doing for time, Kira?
You're doing fine. I have another couple of minutes.
Thank you. So one final impact that I'll just briefly sketch out is the kind of erosion of scrutiny and the role of Parliament, which might seem a bit dry and definitely does in the kind of public campaigning sphere sometimes, but it is incredibly important. And although it was widely reported that the Coronavirus Act would lapse after 2 years, looking at that in a bit more detail, there's actually another provision in the Act that allows the government to extend those powers for a further 6 months and potentially even further still. And on top of that, as the government has kind of repeatedly passed regulations via this emergency procedure, we've seen them just sidestepping parliamentary scrutiny at every turn. And that's really at a time when scrutiny is needed more than ever, and the government's kind of doing all it can to limit that scrutiny. So in terms of where the campaign is going and what we're planning on doing, I started out by saying that the Act was waved through with very little parliamentary debate or dissent as we kind of entered into this pandemic, and there was a lot of unknowns. And 6 months on, I think the failings in the government's response and the other impacts that I've outlined, as they've become more apparent, that's opened up a space for criticism, and certainly in Parliament, discontent is growing. And in a few weeks' time, parliamentarians will have the opportunity to vote on renewing the powers in the Act. That was a kind of safeguard that we managed to get in the Act after a lot of campaigning. But it's quite an attenuated safeguard, really, because it's an all or nothing vote. So Parliament can't say, these aspects of the Act we'd like to keep, but these coercive powers, they can go. So it's a vote on a motion to renew or repeal the Act. And while that's not a very attractive safeguard, it's also a really important opportunity for Parliament to assert their concerns about the costs of the path that the government's taking. And Liberty's been campaigning and engaging with parliamentarians, gathering out evidence from our members, doing public campaigning, all directed towards this review point in a few weeks. So if you're interested in supporting that, and I'll very quickly outline some actions that you could take. First of all, just sign our petition to scrap the Act. If you're a Liberty member, we'll be giving you tools to write to your MP. If you're not, please join. If you work with an organisation that would like to support the campaign, and again, this is an Act, and that impacts so many different groups. We've already built a kind of base of organisations from so many different sectors. working on disability rights, on with homeless people, working on policing, working on protest. So if you're interested in supporting that, do get in touch. If you've had experiences with kind of the use of these powers that you think is open to challenge, get in touch and we'll see how we can support. And we also, if you're lawyers working and advising people, we have really helpful and accessible information on our advice and information hub and bus cards and flyers. So please do make use of those.
Thank you so much for that, Ros. I've just seen somebody raise a hand, but I don't know quite where it's come from. If you have a question to ask, unfortunately, the way that this works is we're all speaking to you, so you can't participate on screen. So please just put your question in the Q&A. That would be great. But Ros, I mean, that's fantastic work. And thank you so much for telling us how everybody can get involved in the campaign as well, because it's going to be absolutely vital moving forward. And it's a nice segue straight into Alice's talk, which is going to be on her work during the coronavirus pandemic on some of these challenges under the Coronavirus Act and the easement of duties. So Alice, without much further ado, I will go straight over to you.
Thanks so much, Chiara. So as was set out very clearly by Ros, some of the measures that were brought in by the Coronavirus Act and were a downgrading of duties to some of the most vulnerable members in society. And that happened in a number of ways. So there were some changes to the Care Act, which Ros was directly referencing around care assessments. But there were also a number of other changes made in different ways. So for example, buried in a schedule of the rather large Coronavirus Act was a power on the Secretary of State to, for example, issue a notice that would downgrade the duties owed to children with special educational needs during the pandemic for a month at a time, and then they could review and renew that notice on an ongoing basis 1 month after 1 month. And so that's one of the big changes that's happened in response to the pandemic. And just to set that out in a bit more detail, I might have a chance to talk about 2 cases, but if not, I'll just talk about the downgrading of duties to children with special educational needs under that provision in the Coronavirus Act. Effectively, in a nutshell, what these legal changes have done is this. So for children with complex special educational needs, they will be issued, if everything goes to plan, an education, health and care plan by their local authority. And that plan will set out in detail what they're entitled to in terms of special educational provision and also associated health provision. Now, if you get that plan, and that plan says you need X, you need so many hours of occupational therapy a week, or you need so many hours of speech and language therapy, then during normal pre-pandemic times, that places a legal duty on the local authority and associated health bodies to make sure that that provision is secured. So these education, health and care plans are really the key for children with complex needs to secure the provision they need to ensure that they're able to have a sort of a fair chance at attending school, or if they're at home, that they're adequately supported. So what the power, as I say, buried in the schedule of the Coronavirus Act enabled the Secretary of State to do was to issue a notice that changed that duty from an outright duty, so you local authority must make this provision, to a duty to use reasonable endeavours to make provision. If you're a lawyer, you will already know how vague the concept of reasonable endeavours is, and one of the important things when we're thinking about this legal change was thinking about the context of the special educational needs system that this legislation came into. So prior to the pandemic, there was systematic failings on the part of local authorities to actually discharge their duties to children with special educational needs. Sort of stark statistics, for example, the local government ombudsman carried out a special review of complaints about local authorities in this area and found that 9 out of 10 complaints were upheld, which is remarkable. So anybody who has any familiarity with the sector knows that it's fundamentally broken. But even prior to the pandemic, children weren't getting the provisions they needed. Somewhat predictably, then when that duty was loosened to be a duty to make reasonable endeavours to secure provision, a lot of these children simply lost all provision or provided with very little or wholly inadequate provision during the pandemic. There's been a bit of media coverage around this, but essentially, I think there's a strong feeling in the community of disabled persons and their families, that they've been largely forgotten in the context of the pandemic, and that essentially the government attitude is, oh, well, you know, resources are under strain, and so we can't possibly give you what you actually need in order to be supported to live a full life. So these notices were issued in to cover the month of May, to cover the month of June, to cover the month of July, to parents of children with disabilities and education, health and care plans got legal aid and mounted a challenge in the High Court, a judicial review challenge to the issuing of these notices, and also to some other regulations, which I won't go into the detail of here, that also downgraded other aspects of the duties owed to children with education, health and care plans. And that case was the case of Shaw, which was heard at the end of the last term. I've got to be a bit careful because I was a junior on the case, so I need to just not say anything that will jeopardise a possible appeal that we're pursuing. Unfortunately, we didn't have any kind of success in the way that Rose has recently had. Congratulations, Rose. So we ran 5 grounds, and all of those were unsuccessful. And there were a couple of issues that I wanted to draw out just sort of as headlines about things that I think are interesting when it comes to trying to challenge some of these changes that have been made during the pandemic. One is a real theme in the courts, and if you've been following any of the judicial reviews in this context, whether that be some of the challenges to changes to financial support. So for example, the Ariatu decision, which was about who was included in the job retention scheme and who was outside it. And other challenges, for example, the Article 39 challenge to the downgrading of duties to children who are looked after, which is another really big one that came through. You'll see that the government's line is a lot of, you should defer courts because this is really difficult and it's all very urgent. It's tough, you can't touch this. So that's something that's being said a lot. The other thing that's really difficult in the judicial review context, and this has come up in a number of cases as well, is the situation is moving really fast. So for example, by the time we got the case of Shaw to court, 3 notices had been issued. It was about to, the July notice was about to expire because we were in court on the 29th and the 30th, and the July notice expired on the 31st. The Secretary of State for Education had made a public announcement saying he would not issue any more notices downgrading that core duty to children with special educational needs unless the circumstances changed or the evidence changed. And then on the basis of that said, well, this is about to expire, your claim is academic, there's nothing for the court, no one going to dispute that the court should be interested in. Now, if you're familiar at all with this kind of line of argument, it's effectively this, it's that courts shouldn't be deciding just points of principle for the sake of it if there's no live dispute still ongoing between the parties. And what we're seeing emerging in a number of these cases is because things are changing so quickly, and because obviously even when you're doing a judicial review very quickly, it can take quite a bit of time to get to court, and particularly sometimes when you're waiting on the legal aid agency to sort of come back to you. By the time you get there, often the government says, oh, well, we've changed because everything's moving in the pandemic, and so what you're talking about back there is academic and the court shouldn't hear it. That came up again in the Article 39 appeal, which was heard last week, which we're waiting on the decision of. So just briefly, the Article 39 challenge was to the downgrading of duties owed to looked after children and another sort of range of very vulnerable people, and again was unsuccessful at first instance, but an appeal was heard last week, so watch this space. So I guess my experience of trying to use sort of one of the tools available during the pandemic to hold government to account hasn't been particularly successful. I think there are real challenges in bringing judicial review claims in the context, as I say, because these are difficult decisions being made by a government under urgency. But I wholeheartedly agree with Ros that it doesn't mean that these decisions should be should not be scrutinised either by the courts or by Parliament. And in fact, one of the grounds that we ran in Shaw was an argument that a lot of the changes that have been made either through legislation that was barely debated in Parliament, or in the case of the regulations in the SEND provision case we were in, regulations that were laid literally the day in Parliament, the day before they came into force. So the government effectively made it so that there was no possibility for there to be any debate. And there's a convention which says you should normally have 21 days where regulations are there so that they can be debated, and that has basically been swept aside during the pandemic. And they're just saying, oh, it's urgent, we need to do all of these things urgently. And one of the grounds we ran in the showcase actually was that the reasoning they offered to justify that very, very curtailed period of parliamentary scrutiny was irrational. Now, it didn't get any kind of traction, and there were a lot of technical arguments around whether the court could touch that, but as I say, the case is maybe going on appeal, so watch this space. Depending on time, Karen, I'll take your lead on this. The only other thing I was going to talk about was a bit more on the personal experience side during the pandemic, of changing chambers or finding myself in a position without a job effectively during the pandemic and navigating that. But is there time for that, Kara, or should we
There's definitely time for that. There's definitely time for that. Please do share.
Okay, so I think I wanted to take an opportunity to share this because the bar is full of shiny people who never admit failure, and it's not necessarily helpful for those of us who are young and battling through and trying to find themselves in a position in the profession that they want to be. So for all of you who are either trying to do pupillage during lockdown or are trying to apply and get going, I wanted to talk a little bit about me during the pandemic. I was third six at the beginning of the year, so I hadn't been kept by my first. I was lucky enough to get pupillage first time round, but then wasn't kept. Went into a third six, and the decision was taken by that chambers at the end of March, just as we were going into lockdown, that I wasn't going to kept. So I found myself at the beginning of lockdown able to squat, which is a delightful term, and in fairness, the chambers were very supportive in assisting me to do that, but effectively without a future laid out and thinking, I've got 2 black marks against my name, and it's a pandemic, how is this going to work? I've since been, I've just started this week at Doughty Street Chambers, which is an absolute dream. And I wanted to just share a bit about resilience and persistence in the face of what can be a really brutalizing profession. I can't believe this worked, but I think it shows it's worth just having guts and grit. Fairly soon after it happened, I put out a tweet that basically said, unfortunately, I join the many people who are finding themselves in a difficult work position during the pandemic. This is my background. If anybody has any suggestions to things I might, do in the interim, I'd be grateful. And off the back of that, a fairly eminent barrister in the special educational needs field, Steve Broach, just reached out to me and said, come and start doing some work for me. And it's through that simply that I ended up working on the cases that I've been working on over the summer and these incredible challenges in the context of the judicial reviews in the context of the pandemic. And that's not to blow my own horn at all. It's simply, I'm looking at time to say, for those of you who've had knockbacks, and I know all of us probably have, stick it out and don't be shy to reach out and network publicly about what opportunities and options are out there, because there are plenty of people in the profession who are incredibly supportive. And I am now in a chambers that I feel is a better fit for me, doing work that I'm really excited about. So these things hopefully do work out. But that feels a bit cheesy, but there we go. I'll hand back on that somewhat hopefully uplifting note.
I think that was hopeful and uplifting. That was really great. And I love how when you said, we suffer knockbacks, everybody was like this. Yes, we do. And actually that's the thing, isn't it? Because obviously we started with Rose's story, which is this incredible victory, but actually that's not our everyday. And it does take grit, it does take persistence, and we will fail. And actually, thank you, Alice, for talking about that, because that's something that you're right. Like the barrister's profession in particular doesn't talk about failure, but I don't think junior lawyers at all really do. It's not something that we particularly embrace or discuss, but it invariably happens, and particularly in legal aid. So thank you. And now moving on to our last speaker, Lady-Gené. So you are a pupil barrister at 25 Bedford Row and probably have had the wildest time of all of us because you've been in the magistrates' courts on your feet. So we're really, really looking forward to hearing some more about that. And so just over to you.
Thank you. Yeah, it has been mad, I think, to say the very least. So just for context, I started on my feet at the end of May, like actually practicing properly, because we were meant to start around April time, but obviously everything was delayed. I had my first ever hearing, which was actually an in-person hearing at the end of May, which was a really great way to start Second Six. So I've been on my feet since then. I've had quite a few in-person hearings and some CDP hearings. So just to sort of talk about how that works and the impressions that I've gotten as counsel, but also the impressions I get from my clients. To start with virtual hearings, I think it is oftentimes heralded as like the way forward. Virtual hearings is what we need to be doing. And I appreciate that there is a time and a place for virtual hearings. Unfortunately, for most of the hearings that I've had, I've found the use of virtual courts actually quite detrimental. Just from my own perspective, I found it very difficult and quite disorienting looking at a screen. Because when you go to the magistrate's court, you know who's who in the court, you know what the layout is like, you know how to project your voice, you know when to raise it, when to lower it, and it seems much more natural. So for me to see this all on a screen, especially because the camera is usually, so when I'm at home and I'm looking on my screen, I see the legal advisor and I just hear voices in the background. Obviously, I'm aware that that will probably be my client or my opponent or the bench or people who are supposed to be there, but it is quite disorienting. And just from a personal perspective, I don't think I've ever delivered my best advocacy via CDP. But it's also, aside from it being disorienting, it often happens that I'm just not heard or I can't hear those speaking. So the prosecutor might be speaking, so we only defend, so my opponent's always going to be the prosecutor. So he might be speaking, which he's supposed to be, and I wouldn't have heard a single thing. And I'm not sure, am I supposed to respond? Because then the legal advisor is sort of then looking up to me, and I can tell that people are expecting something of me, but because I wasn't able to hear what my opponent has said, I don't know what I'm supposed to be saying. So that's not been great. And I think it does for clients also not instill a lot of faith in their counsel if they don't know what they're supposed to be saying. So that's quite difficult. In terms of engaging with clients, I find it very difficult over CDP also. So you have two types of clients, either those who are remanded or those who are on bail. If they are on bail, I will have, if I have good solicitors, been given their mobile numbers and have a way to contact them, because obviously I won't be having a face-to-face hearing with them. So I'll be appearing from home on my laptop and they will be at their local court. So I'll usually have been given their phone number. We can have a chat with them over the phone, explain the charges and what we're going to be doing in court. That is kind of helpful. Again, I think in general, it's better to see the person you're speaking with, especially when it is about going to court. It's never an easy thing. You'd want to have seen the person, spoken with them face to face. And you don't have that opportunity. Sorry about that. And but yes, over the phone, it's fine. You can make a good enough impression, but it's obviously not the same thing as face to face. With those clients who are appearing from the police station, I find that very, very difficult and very challenging, because they'll have been arrested the night before and they'll be at the police station. And the way that works as well is that you're given a number for the police station where you call. For Saturday courts, for example, that's particularly difficult because every single pupil barrister in the country is doing Saturday courts, and we're all trying to call the same couple of police stations. You don't get through, you don't get to speak to your client until ages later. And even when you do get to speak with them over the phone, there's obviously no way of knowing who's with them there. They're supposed to be by themselves, supposed to be confidential, but obviously I can't enforce and I can't check whether there's someone standing behind them. So I personally find that quite challenging. I'm not sure how to deal with that at times. And then afterwards, you then go on to actually being in court. So you've had your client either over the phone or over the phone from the police station. And again, I think for the client, it seems quite disorienting because they will have heard my voice, but again, they just see the legal advisor on the screen, or they see a weird angle of the courtroom. I had a youth client who was basically staring at the screen, didn't know what was going on, and he was like, "Well, which one's my lawyer? Which one's my lawyer?" I'm sorry, please forgive me 1 second. Pina, kannst du bitte einfach durch? Ich kann dir nicht helfen gerade. I'm sorry.
No, it's all right. Do you want to introduce Peanut to the audience?
I think he's going to act all shy all of a sudden. I sent him to the shower and now he's pretending he doesn't know how to use the shower. He knows. I think he just wants attention. But yeah, I might have to get up, but I think he'll be fine. Yeah, in any case, so I've lost my train of thought. Oh yeah, I had a client sort of staring at the screen saying, like, which one's my lawyer? Which one's my lawyer? And it was when I sort of made myself aware to him that he was like, all right, you're the one who's for me. So I just think for clients, it's probably not the best way forward. It is a way forward. I'm not convinced that it's the best way forward. And then again, from a personal point of view, again, as a defense, it's happened to me a number of times where myself, my clerks, solicitors have made applications for me to appear virtually from my home. So we're speaking about Saturday courts, for example, most recently when I was in Luton Magistrates Court. And requests were made for me to appear via link, and they were ignored. They were ignored for a couple of days. They were ignored on the day. So I trekked over to Luton, which I would have done on any other, when it was not coronavirus time, and that would have been the norm. But once I arrived there, I realized that everybody except for myself and obviously the bench was appearing via CVP. So probation was on a link, the prosecution was on a link, and it was just this very blatant inequity, how you might call it, between all parties and the defense. So that does leave a bit of a sour taste in my mouth. Going then to actually in-person hearings, it has been better because they've happened at least at times. I think it was twice, if not 3 times, where I was able to experience firsthand the implication of what's called bucket courts. That's when courts will list hundreds and hundreds and hundreds of hearings in a day. All of the people will attend, usually for first appearances, sometimes for sentencings, just to be told in person that actually your hearing has been administratively adjourned. Here's a piece of paper with your new date. Or at times even there is going to be a new date, but we don't know when it is. You can stick around until you find out, or you can hope we'll send you a notice. So this is something that myself, and I know a lot of other pupil barristers, have been tweeting about and talking about, and sort of really trying to get out there to just show people, because I appreciate not everybody spends their time in the magistrates court, so it's quite difficult to fathom what that might be like. But the court that I was in, I will name and shame it, it was Highbury Corner Magistrates Court. It's a nice modern enough building, but it's not humongous. It has a finite amount of space. And there were hundreds of people and more arriving, just crammed into this little foyer reception area, trying to find out when they're going to be heard, whether they'd be heard today, tomorrow, next week, or next month. And it was just a sense of absolute and utter frustration, which turned into outrage, which is understandable if you think about the wasted cost, the wasted time, the risk that people are exposed to by being on the tubes, on the buses, in this small amount of space as well, which is utterly unnecessary. And then there was this one, and it'll stick with me for the rest of my life, I think. There was this gentleman who I wasn't representing that day, but he had been told that his case had been adjourned, and he broke down into tears. He was grown man. He was crying, explaining that he's in receipt of benefits, and he doesn't get enough to afford a train ticket back and forth to Highbury Corner Magistrates Court, because he wasn't local. And he'd explained that basically he'd starved himself for a couple of days a week in order to save up money to be able to afford a train ticket. And so the knowledge that he would just have to do that again in another day, a week, a month, like I said, was unbearable to him, which was understandable. So he was sobbing. I've seen it only once, where a person was actually seen by a district judge, she was, and explained that, he had gotten a letter and he didn't understand why he was supposed to be there. He was told that it was adjourned. And she's the only district judge that I actually saw immediately consider whether he could be compensated in some way, whether his costs could be covered in some way. But obviously when you have bucket courts with hundreds of people, getting your costs back is basically impossible. So that's been quite terrible in terms of bucket courts. I've recently had a client, because it doesn't just affect first appearances, like I said, it's sentencing sometimes. And I had a client who has been remanded, and he was just awaiting sentencing. And he'd been remanded in order to obtain a pre-sentence report for his sentencing. And when I went to see him, this was the second time I think his sentencing was adjourned. He told me that he didn't have his interview for the pre-sentence report because probation wasn't able to get either a video link or an in-person visit into the prison. Now, this is something that's known to defense. That's been the case for quite some time. A lot of cases and trials are adjourned and delayed, and we're not trial ready because we can't see our clients. I wasn't aware that this happens to probation also, because in my head, I thought they're more in the system than the defense might be. But then to find out that he hadn't been seen by prosecution, even though, like he said, it's not like they don't know where I am. He was remanded. So I went and spoke to probation, and they told me that just like ourselves, they're having difficulties getting video links and so on. I thought in this case, it was particularly difficult and heart-wrenching because he was remanded, and he had been remanded for 6 weeks, I believe, at this point, and he was just awaiting sentencing, but it was for sentencing. So I just feel like coronavirus delays and, you know, the inability to get your clients on the phone, your clients on video link in any capacity is causing incredible delays, shocking delays in some cases. And what I find particularly difficult is that you don't really know where to turn your anger. So when it came down to probation that day, it was something that I could do something about, because my client had been produced to be sentenced, only to find out that there was no report. But I was able to go upstairs to probation and tell them to go down to the cells and at least interview him in person while he was there. So his sentencing has been adjourned, but at least he's got his interview now. I think he's going to be sentenced this week or next week, I believe. So there was something I could do there, but you know, when you have a client in front of you who's been adjourned off, who's, you know, trekked from far and wide, there's nothing you can really say to them other than, I'm really sorry, which just seems so useless and empty, and it's just not helpful at all. And I've been finding that very frustrating and very disappointing, because obviously you always want to do the best. Hopefully you want to do the best by your client. But I just oftentimes feel that my hands are so tied and there's nowhere to turn. Obviously, I have been tweeting a whole lot, and I intend to continue doing that. But oftentimes it's a bit like an echo chamber, because everybody I'm telling about this is like, yeah, girl, same. But I just wish there was more immediate accountability. You know, even when you've made a complaint, there's nothing tangible coming from it. So yeah, that's a really bleak ending to my to my part of this. But yeah, it's not great. Obviously, when things work the way they're supposed to work, which is not all the time, you can do your job and you can do it properly. But there are just too many instances where things are delayed unnecessarily. Yeah, I mean, I could go on, but I feel like that was negative enough.
You know what? It was really insightful. It was negative, yeah. But that's the situation, isn't it? You can't do anything about it. That's what's happening.
Yeah.
Have you seen any improvement during the time?
No. Some. Okay, no, to be very fair, I think when you're physically in court, I can praise Highbury for that. You know, in the beginning, it was just really, really full, really packed. Obviously, they've stopped with the bucket courts. I haven't seen any bucket lists in quite some time. And I have also noticed more hand sanitizer, more social distancing. There are masks available for free, like disposable ones. But then you do still see things like security staff telling you to put on a mask while they don't have a mask on, which is completely, yeah, Rose is like, yes. Which is, yeah, so that to me is completely ridiculous. I can see that attempts are being made, if I can put it that way, but I just don't think it's enough, and it's not enough for me to praise yet.
Fair enough. And I see, because you've been tweeting HMCTS and stuff. Have you ever received a response?
Not even one. I did one time saying, can you please identify the court? And that was it.
Great. That's really useful.
Yeah.
Well, thank you so much. Really appreciate the insight. We have got a few questions. Please, audience members, do send your questions in. We've got one, I think, that's gone into the answered box there that's for Alice. The first one that we had was from Becky Kingy, who's actually on the committee, and it's for Ros. She was actually WhatsApping me during all of your talks saying, these speakers are so great, they're so great. So very enthusiastic. But the question is this: what are the biggest hurdles you've had so far with the campaign? How are you finding public and media engagement?
That's a really good question. Thank you for that. The biggest hurdles, I think, I kind of alluded to this earlier, but I guess we are just campaigning in a pandemic is really hard. We're really stretched, and all the other issues we normally work on are still happening. So, you know, stop and search in London reached its highest in over 7 years during a pandemic when nobody was on the streets. The government's still pushing through legislation on counterterrorism at the moment, and their executive power project marches on. They've just announced an independent review of administrative law, which lots of you will know already. So yeah, that's just kind of doing a campaign of this nature while so many other things are going on is really challenging. And really practically, like, you know, when you're trying to build a constituency and kind of have parliamentarians who are going to be at the vanguard of a campaign. All of our meetings are on Zoom, as everyone's are. It's harder to build a rapport. I know, yeah, lawyers, you'll be familiar with these issues, but it's just, we've had to think creatively about even just some of the kind of standard campaigning tactics we'd use, and how we're going to affect change, and how we do stunts and hand in petitions and all those kind of more banal logistical things. That's been quite challenging. I guess thinking specifically about the campaign, the all or nothing nature of the review is a challenge, right? There is some good stuff in this act. It's not all absolutely terrible, you know, allowing kind of doctors to re-register who've been retired, like there are some positive provisions. So really making the case for why parliamentarians should vote against it in its entirety is a challenge. But I think how we kind of mitigated that was making sure we launched the campaign before the summer and did quite a lot of comms with our kind of vanguard MPs around the government has this summer ahead of itself to do its homework and to think about, if this act is repealed, what could replace it that would be rights respecting and kind of put public health and our rights at its heart. And yeah, I think there's some other stuff that's just been quite challenging, but really interesting from my perspective, working on more the policing side of things. I think there's definitely an assumption. We came out quite quickly when a lot of these measures were announced, with the line that this is a public health crisis that needs a public health, not a criminal justice response. And I think at the time that line didn't get that much cut through. But I've actually noticed, I've seen it being repeated far and wide, which is exactly what you want with a campaign. You want a message to get more and more traction. And so I think we've kind of been successfully challenging the assumption that, you know, we always have to resort to criminal justice measures and handing the police massive powers that don't say criminalization is a last resort on the face of them. I think we've kind of been challenging that assumption, but that assumption was definitely there. What was the second part of the question about public and
how are you finding public and media engagement with your campaign?
So again, it's really hard to cut through the news cycle at the moment, and people have a lot of other things on their mind and on their plates. But I think actually what makes this, you know, a campaigning intervention is, what makes this campaign kind of quite tightly bound is that we have this review point and we're kind of working towards that debate in Parliament. And hopefully, I mean, the debate, we don't have a date for the debate, but it has to happen before the 3rd of October. That's what the legislation says. It has to be within 6 months. So we're really hoping to kind of build up more pressure and working to do some strategic comms and kind of media work in the lead up to the debate, when we kind of have that as a hook. And I think also, you know, there are things in this act which exercise a really broad range of stakeholders. So hopefully when it comes to that parliamentary debate, we'll have a broad church of concerns, you know, so we'll have civil libertarians concerned about the expanse of state power and the kind of the police powers and the powers to kind of police people's everyday activities. And we'll also have people who are concerned with social care provision, people who are concerned with who's been left behind in this pandemic response. And we'll have people who get very excited when Parliament is sidelined. So I think we've got kind of a broad range of concerns, and actually hopefully that parliamentary scrutiny should unite everyone in Parliament, and kind of potentially, yeah, we'll see what happens and see, but hopefully we'll see kind of voices from across the House coming out and raising their concerns.
Definitely, and you've certainly got all of us behind you. I mean, it's part of the problem, I suppose, like you say, cutting through the media, and then also like what Lady-Gené was saying about Twitter being kind of an echo chamber as well, and kind of breaking that and breaking into places that ordinarily you do so face to face. So it is really, really difficult. Rose, is there anything that you want to add on that add to that from Shelter's perspective? Because of course, a lot of your campaigning is sort of the same, isn't it? And in terms of the stay on evictions and everything that's going to happen after the 20th of September, how has public engagement been with that campaign? Do you know?
I mean, I always feel, especially when I'm speaking at events where I know there are lots of legal aid, lawyers, that we're just very, very lucky that we've got the capacity that we have, the number of staff that we do, their experience, our public affairs team's just very good. I know that they have struggled over the past couple of months, just as Ros was saying, it's just so difficult. If it's not about Brexit and it's not about the government's position on COVID, it's really difficult to break through. So they are definitely relying on relationships and networking from pre-lockdown. I think it's very difficult to make new ones at this time. And I think it's just, obviously Liberty's got this fantastically big brand, and I think sometimes in the charity sector you have this like massive brand, but actually like the number of you underneath is like it doesn't really, you have this fantastic reputation and really punchy and powerful, but like the actual capacity to get stuff done, especially some of our staff have had COVID, there have been people unwell, we had to furlough some people, so I think it's like we've had a good capacity, and that's helped us.
Yeah, and ultimately it does come down to that, doesn't it? And actually it's quite interesting, because I have always thought of Liberty as this huge organisation, but of course it really isn't. So no, fantastic in the circumstances, and just anyway. Alice, you have tagged a question to answer. Would you like to read out the question and then give your answer to it?
Sure, I do need to give you warning that I'm getting that very alarming "your internet connection is unstable" banner. So if at any point anything happens, let me know. So I've got a question about the potential effect of the review of administrative law that has already been mentioned on the kind of judicial reviews that I was mentioning about downgrading of duties during the pandemic. And I think those instances of litigation, so the kind of strategic judicial review challenges that have been brought on a number of different fronts during the pandemic, and I know there are others in the works, are a really good example of why we need administrative law and why we need judicial review, particularly when other aspects of sort of scrutiny, parliamentary scrutiny and so on, are being curtailed. I think the sort of headline is obviously we're all really, really concerned, and it's probably precisely these kinds of challenges as well that the government isn't particularly keen on, because they're being questioned. You get disclosure of the background information with internal ministerial documents around decision making, and that's always sort of fairly interesting and alarming at times. And it's not the kind of scrutiny that the current government seems willing to put up with, despite it being a sort of a rule of law issue. I would say the one thing about the kind of direction that pandemic challenges have gone does indicate that the courts are very aware of the limits of their role in the current UK constitution. I'm not aware of a single challenge to a pandemic measure in a judicial review context which has been successful. Somebody can correct me if I'm wrong on that front. There are others in the works. But it does show that there is a balance that's struck quite carefully by the public law principles that are applied, that sort of it belies this idea of the courts, running in roughshod and making overruling Parliament and taking on a role that's not appropriate. I think the main frustration I'm sure for most of you who know anything about it, but for those of us working in the sector, is just that there's such a poor public understanding of what the role of the courts are in these cases. And certainly we're not, there's been some media coverage, for example, of the impact of illegal changes on children with disabilities, but little to no coverage of the actual case and the challenge. and how that actually works in practice. If we'd won, it would have gotten coverage, but again, it probably wouldn't have been covered in enough nuance for the average. Intervene in a question like that. So I think they're interesting case studies. They're the sort of challenges in the pandemic of both the importance and the limits of judicial review.
And you have actually got another question there as well from Tom Huxma. He says,
yeah.
Alice, wow, this is interesting. You got a wow. This is interesting to show how both the brutality and the kindness of the bar in terms of employment and employer attitude, even in the independent bar. How have you found the support attending those 8 out of 10? So that's just separately about your own experience at the bar, then on to tribunal work. How have you found the support attending those 8 out of 10 tribunal appeals that have been successful? Have the families been given access to the tribunals with these best endeavours?
Right, so apologies if I wasn't entirely clear. So when I talked about that high rate of success, that was about complaints to the local government ombudsman prior to the pandemic. So that success rate in terms of complaints being upheld was before anything of an emergency nature was happening. That was just the parlous state of the SEN system before the pandemic even came along. When it comes, sort of SEN is interesting because you do some things in tribunal, the duty to make provision if that isn't being met, the route would be judicial is obviously incredibly sort of onerous and difficult for families to engage with. I'm not aware of a single case being brought to challenge a failure to use best endeavours as of yet. And obviously the notices are no longer enforced. So, you know, we're technically just within time for somebody to do that, but again, it would likely be academic. And I think the big issue in relation to that sort of reasonable endeavours test, which is what the duty was changed to, is just how slippery that is and how much discretion that gives the local authority to determine, you know, have they used reasonable endeavours or not. And so certainly I didn't have a client ask, you know, can we push the local authority on this? But I wouldn't have been advising of strong prospects in bringing a challenge of that sort. I think that was a sort of a key plank of the concern in the sector, was that it was all far too vague. So sort of the downgrading, they were sort of fudging it like they did in so many areas, where it was kind of like, just do your best, and then there was the trust that the sector would respond well to that, and that's unfortunately not what we've seen. So sorry, Tom, if I wasn't totally clear about that context, but we have had tribunals going on remotely. My lovely little cat here has attended the Senders Tribunal via Zoom, which has been entertaining, and I would echo some of the kind of difficulties that's been sort of doing that kind of thing remotely. So I had a family who were attending in relation to a school placement dispute for their child, and they didn't have a laptop. They were trying to join using their mobile phone. They were the only person in the whole process whose camera wasn't working, so we couldn't see them. They couldn't really see us, but the panel decided to go ahead on the basis that they had audio. But you just wonder about what that feels like in terms of engagement, and obviously it's sort of a decision-making process that's profoundly significant for their family when there's that level of kind of technical exclusion on top of the ordinary kind of exclusion people feel when engaging with difficult kind of legal processes. So it's been a challenge.
Yeah, definitely. And actually, because I had an interesting experience the other day, because I do a bit of parole, and I had always thought that if you're going to have a remote hearing, it would be better to have it by video than it would by telephone. The only exception to that so far that I found is the parole board. Because what happens when you have it by video is that your client is just on screen the whole time. And it's the most exposed position I think I've ever seen anybody in. So unlike when you're in a courtroom or when you're on CVP normally, you might see the judge or the speaker or whatever. You just see this person on their own in a room, just staring at not only the panel, but then also their legal advisor and their offender manager in the community and in the prison. So it's a really, really daunting prospect. Lady-Gené, does that happen in the criminal courts as well, or is that an entirely different experience?
So I'm not sure what my clients actually see. but they don't seem to see very much. So when I was describing the youth client sort of looking around, so I think he could see me and he could see the legal advisor, but he just wasn't sure who's who on the screen. I've noticed a lot more recently, like over the last month or so, that when you do have clients appearing from the police station, there is an officer sitting next to them or close to them who then actually does act almost like an interpreter, which I'm grateful for the assistance, but I'm not sure how I feel about it. So it might be the case that you know, my client wouldn't have captured something or quite understood something or quite heard something, and the officer who's more sort of versed in the wordings that we use, the words that we use, he would then just sort of explain things to him. I've had it where I've had a client sort of almost be given advice by an officer, whereas like, okay, now you need to stop. Thank you for like explaining things, but don't give them advice. So in terms of what they can see, I'm not actually very sure, but I do know that there is like obviously the square screen, and then they've got like small windows, so you don't see the entire court layout. You just sort of have bit by bit, if that helps.
No, it does, and it makes it so artificial, doesn't it? Because my client was just there vaping, and I was like, "Please stop! Please stop!"
Yeah.
We had Moni has got in touch on the chat, and she's just said about other challenges, and of course, one of the big wins during the coronavirus pandemic has also been the challenge to the legal aid fixed fee for immigration and asylum matters. I suppose you were talking about ones that were specifically linked to the Coronavirus Act as opposed to the pandemic, or?
I think I was speaking more generally about cases that fought all the way to hearing, but I think that the point Moni is making is a really actually excellent one. So there has been a number of instances in the current pandemic where pre-action protocol later has done the trick. And for example, in the disability sector, there's been a lot of this. When the lockdown first into place, and you had the underlying law didn't say you couldn't go out more than once a day, but the guidance that was issued said you couldn't go out more than once a day. There was pre-action protocol letter, for example, in that context, arguing that was indirectly discriminatory to cohorts of disabled people, such as people with autistic spectrum disorder, because they needed to be able to leave the house more often than that to manage their conditions, and it was causing quite considerable distress to that cohort. And that guidance was amended simply following the pre-action protocol letter being sent. And there are lots of examples of those kind of wins going on during the pandemic. So I don't want to paint an overly pessimistic picture. I would say that unless you sort of have the government sort of relatively over the barrel on the legal arguments at that pre-action stage, and you know, they go, okay, we didn't think about it, or fine, we'll just fix it. Once you get the cases that fight, that's where I'm saying I haven't seen any of them succeed. But again, I might have missed something. And as I say, some of those cases are working their way through to the appellate courts now as well. But certainly the pre-action protocol letter has come into its own during the pandemic. So it's always worth considering as a way of applying pressure.
Definitely. And Ros is nodding enthusiastically to that as well. Is there anything that you want to add to that, Ros?
No, I've just been watching and cheering that on, that's all.
Because I know Liberty got involved actually with the legal aid fixed fee campaign as well, I think, around about the same. There were lots of campaigning bodies. Obviously, we did a prayer for legal aid as well, and everybody was up in arms about it, which was really great, because it seemed to people who didn't know immigration and asylum legal aid fees to be a really minor thing, and why were we making so much fuss? So it was really, really good. So yeah, okay, so we don't have any more questions at the moment. I mean, folks, if you have a question for us, do get in touch. What I would like to ask you all, because obviously we're talking about the coronavirus pandemic, there have been very kind of mixed impressions of it, things like highs, massive lows. What is the one thing, if anything, that you will take away from this last 6 months? If there is anything that will stay with you. Shall I start with you, Ros?
I think I might need another minute, Kira. I'm dredging up. I don't mean to put a totally negative spin on it, but I think one thing that will stay with me is definitely how much I value my colleagues. And I mean, being amongst my colleagues, I've really missed that. And getting to meet with the organizations we partner with and the people we work with. And we've kind of recreated that in various ways, and there's been like an enormous amount of time and effort has been poured into trying to kind of recreate that connectedness when you're working on the kind of issues that we're working on. And I'm super grateful for that. But yeah, that's something that I've realized is just like an incredibly important thing, and the kind of, it's been just very important for feeling resilient and getting through it all.
I think Katie Watts, actually, she's just come over to Liberty. I saw a tweet of hers where she was like, people have told me to turn my phone off after work and I'm doing 35 hours a week. Like, what is this? This is amazing. Yeah. So you really have hit the nail on the head in your organization.
Yes, we rigorously enforce contracted hours.
That's excellent. Rose, what about you? What's your one big takeaway from the pandemic?
I'd be cheeky enough to. I suppose echoing Ross a bit in that I've been quite excited to see how quickly some adaptations that disabled people or people with caring responsibilities, obviously people with protected characteristics largely represented, have suddenly been allowed to work flexibly and in a way that suits them, and to access each other and you know, have communities. And I just think, you know, people have been asking for that for so long, and then all of a sudden it's like, oh yeah, we can do that, you know, you don't need to come in, we can do it like this. And I just think, oh, finally. And I really hope that that stays. And obviously the flip side of that is the digital exclusion of vulnerable people, and it's just been so frustrating to go from being able to say to vulnerable clients, I will be here every Wednesday, just drop in, it doesn't matter, you don't need an appointment, just come and see me, I'm here. Not being able to offer that has been, yeah, heartbreaking. So I'd like in the future for us to get the best of both worlds to carry on. That would be great.
Yes, definitely. Free internet and mobile phones for everybody. I think didn't they trial that? Wasn't that part of the Labour Party manifesto? Anyway, moving on.
Actually, with a policy advisor to that Labour campaign who wrote that policy, and so now every time in the news people are like, oh, everybody should have free internet, he's like, it's what we said all along. Sorry, anyway.
No, well, while we're on you, Alice, what's your one big takeaway then from the pandemic?
Can I have two? Sorry. So yes. One is actually echoing very solidly what Rose has said. So working in the sort of disability rights sector, in terms of accessibility, there is a lot of sort of technical things that can be done in ways in which people can be given opportunities to access forums and so on that have sort of been the too hard basket, as I say, when it was only just a minority of people who needed those things. And now that we're all kind of stuck at home, suddenly it's easy and it's all being done. And so I do hope that does mean that there's continued rollout and the recognition of it's actually hard to find workarounds when people have special needs or other systems that they might be able to access services or anything in the way that you know, traditionally things have been accessed. So fingers crossed that we do take away some positives from that. The second would be just that the bar is you know, while it's can be really tough at times, is full of people who are keen to support young barristers and will really give you support and champion you, and you'll feel humbled by the support that you can get when you find those good ones. So I know that there's a lot of YLL sort of alumni, I guess, who are out there who are really looking out for young lawyers. So if you find one, be grateful and be encouraged as well that there are people out there who are keen to mentor and to take people at the beginning of their journeys at the bar under the wing. So thanks to those more senior members of the bar.
Yeah, and that is really hopeful. I suppose we just grow it from the bottom and eventually we get to the place where we want to be, right? Lady-Gené, what's your biggest takeaway from the pandemic?
My biggest takeaway is probably how convinced I am that I love this job, that it is okay, I'm coming off my shots, and that I don't want to have a kid. No, to be honest, it's that I really, really love my job. It's been so challenging in terms of getting physically to my job, getting papers late, speaking to clients over the phone, in the cells, all of these things. At the end of the day, I know why I keep doing it. It's not been long on my feet, but you know, if I can do it and I enjoy it, even in these situations, then I'm really encouraged to keep on doing it. And I've, despite everything, despite what I've said, I really have enjoyed myself because I know why I'm doing it, and I feel more encouraged than before to carry on with this. So I'm really grateful for that. And I think I can only just echo what Alice has said in terms of reaching up and reaching out to other people at the bar. It can be such a supportive environment if you know where to look and if you know how to reach out and if you're not afraid to do that. It's endless almost.
Brilliant. And I do think that's such a positive way to end. I mean, we have a YLAL mentoring scheme. So if anybody is kind of unsure of where to look for a mentor, then we have loads available in both the solicitors and the barristers profession. There's also Bridging the Bar as well, because they've got their mentoring scheme that's now up and running. I think Queer Lawyers of Tomorrow also have one. So there are suddenly all these like great mentoring schemes coming up that are just it's just fabulous. It's really, really brilliant to see, and that people are supporting. We usually end our meetings on a poem, and I went through, because Emma Trevor and I think it's John Whitfield QC, curated this book. I think you can sort of see it. I'll take off my background and then maybe you can see it more. They curated this book, or edited it, of poems during lockdown. So it's Lockdown Lawyers, you may have seen it. It's actually brilliant, but it is quite dark. So I was trying to find like a funny poem or something to end on, and I just couldn't find one. So in the end, Rebecca Kingy wrote me a limerick. So I'm going to read it to you. But I just have to find it now because it's in, oh, here we go. Here it is. It's very short, as limericks usually are. So here we go. There was once, God, I've buggered it already. Here we go, second try. There once was a lawyer in town, looked great in a wig and a gown. The love of the law kept them happy, but poor, would have made more dressed as a clown. Well, I mean, it's not really that happy, but at least it rhymes. Thank you all so much for joining us tonight. You've been really, really wonderful. And thank you again to One Pump Court for hosting us. It's been a real treat. I hope you all enjoy the rest of your evenings, and hope to see you again soon. Do you have anything that you want to say before we go? Everyone's shaking.
Thanks, Cara. You did a fantastic job. Well done.
Thank you so much for having us all.
You're all really welcome. So I'm going to end the session now, and thank you again. Bye-bye, everyone.